Hello, everyone. Thank you for logging on this afternoon and for your interest in this legislative update. I am Melanie Cuevas. I am the Vice President of Government Affairs and one of 3 lobbyists at the association. I'd like to first say that it is an honor to represent our members and the banking industry here in Sacramento. We appreciate the work that you do, and we appreciate this opportunity to provide you with a legislative update where we will specifically focus on measures considered during the 2020 legislative session, which may create new burdens for you from a compliance perspective. I'd like to set the stage and to first provide you with an overview of the status of the legislative session. Where are we now? The governor's deadline to sign or veto all legislation is Wednesday, September 30th. He had 30 days to consider all of the measures that the legislature sent to his desk. Their deadline to finish all legislative business was Monday, August 31st. Ultimately, they gavelled down in the wee hours of Tuesday morning, and our advocacy team was in it with them until the end. Looking forward, the general election will be held on Tuesday, November 3rd. The governor signed an executive order back in March to mail voters their ballots this election in response to the COVID-19 pandemic. This was implemented to avoid exposing voters to the long lines that Californians experienced last year. All ballots will be mailed out by October 5th or perhaps sooner, depending on the county. And a helpful hint for everyone, the Secretary of State is offering voters the option to track their ballots this year. You can do so by logging into where'smyballot.sos.ca.gov, which we will put in the chat box, to receive email, text, or voice call notifications about your ballot. After the election, the Senate and the Assembly will meet for what's called an organizational session on December 7th. At that point, members are sworn in and they can start introducing bills. We usually expect to see a few high priority measures introduced at that time, but the real work, the committee hearings, the votes, the budget, begins in earnest in January when the legislative session commences. Looking retrospectively at the legislative session, I will also note that we saw just over 2,200 new bills, not including resolutions and constitutional amendments, introduced at the February bill introduction deadline. That's a fairly typical number. That was also pre-pandemic. Since that deadline, the dynamics in the legislature have changed dramatically. On March 16th, the Senate and the Assembly approved a $1 billion allocation for the governor to appropriate towards COVID relief before gaveling down for an unprecedented recess. The legislature ultimately reconvened in the beginning of May, and leadership encouraged members to only focus on measures that provide relief related to COVID, wildfire, or homelessness. As a result, the legislature's workload decreased from that 2,200 originally introduced to several hundred bills. Interestingly enough, the policy areas that were still in play tend to impact the banking industry. The legislature has kept an eye towards mortgage forbearance, tax policy, debt collection, consumer privacy, restructuring the DBO, employment-related issues, all of which we will dive into here today. Not that we need a reminder as we participate in this virtual conference, but I'll note that the typical way of doing legislative work was turned on its head this year. All advocacy efforts pivoted to a virtual format. Government relations and the policy work that our team does is largely a relationship-based business where we engage in direct negotiations face-to-face on nearly a daily basis. But in 2020, the entire Capitol community was forced to rely heavily on existing relationships, resorting to email communication, Zoom meetings, conference calls, and even telephoning into committee hearings to testify on behalf of our members in the banking industry. Legislative offices were limited to 1 staff member at a time, and the entrance to the Capitol itself was heavily restricted. And while some legislators were present in the Capitol to vote, some voted remotely. In fact, during the last week of session, every member but one of the Senate Republican caucus was required to quarantine and to vote remotely due to one senator's positive COVID-19 test. To further complicate the typical legislative workflow, the legislative process was truncated, and to meet deadlines had to be significantly streamlined. This further limited opportunities to influence, to secure amendments, or even to kill a bad bill. So just like the rest of the world, it has been far from business as usual in California's capital. Now that you have some context regarding the broader legislative session, let's dive into some specific issues and measures. Again, if you have questions about any of these, please feel free to submit those questions into the chat box and we will do our best to provide you with some further information. Let's start with a measure on cannabis banking. Assembly Bill 1525 by Assemblymember Reggie Jones Sawyer. This was actually a 2-year bill, meaning that it was introduced in 2019 but approved in 2020. It was one of the few 2-year bills that did get to move forward this year. Just like banks, cannabis retail facilities were considered essential and continued to operate throughout the closures associated with the pandemic. So the industry's reliance on cash is still top of mind for many lawmakers in Sacramento. Of course, there are no complete solutions at the state level that allow a licensed cannabis business to access the same level of banking services that other businesses currently receive. The risk associated with compliance requirements and persisting conflicts between state and federal law remain concerning, and this measure is intended to be a remedy towards addressing some of those compliance concerns. AB 1525 aims to help increase the availability of financial services for licensed cannabis businesses, and it has 2 key components that support that goal. First, it provides financial institutions with increased access to verified third-party information about cannabis licensees. Specifically, this measure authorizes cannabis licensees to request in writing that a state or local licensing authority share their application, license, or other regulatory and financial information with a financial institution of that person's designation. The measure also offers coinciding authority for licensing agencies to share that information upon receipt of a written request. It's important to note that these provisions are voluntary for both the cannabis licensee and for the financial institution. The measure does not force or compel any sort of financial relationship. By authorizing cannabis licensing agencies to share specified information with financial institutions, the hope is that those financial institutions will be better equipped to comply with Know Your Customer due diligence requirements and to appropriately file those suspicious activity reports with FinCEN, reflecting the degree to which the marijuana-related business, or MRB, is complying with the state's regulations. As of March 31st, 2020, FinCEN received over 125,000 suspicious activity reports involving MRBs. Just over 95,000 of those were considered marijuana limited, indicating that the MRB does not raise any red flags and is compliant with state regulations. The second component of this bill provides that an entity, as defined, which provides financial services, does not commit a crime under any California law solely by virtue of the fact that the person receiving the benefit of those services engages in commercial cannabis activity as a licensee. This is intended to be a safe harbor provision, although it does not and cannot address conflicts with federal law. The measure is based on a recommendation from the State Treasurer's Cannabis Banking Working Group and is also modeled after existing law in Washington state. Until a federal level solution is achieved, providing financial institutions with the necessary access to the data that will allow them to better evaluate potential customers, as well as matters associated with compliance and risk, this measure may be a helpful band-aid for both cannabis licensees and for banks considering a financial relationship. We will now transition from cannabis to debt collection. There's 2 items in this category that I would like to place on your radar. The first measure we will take a look at is Assembly Bill 1885, which is a change in the homestead exemption. This proposal stemmed from the Senate Democratic Caucus Working Group on Economic Recovery. Under current law, in the event that a debtor files a bankruptcy or if a creditor is seeking to collect on a money judgment, the judgment debtor can declare certain property is exempt, the most significant of which is likely the debtor's homestead exemption, which provides a certain amount of equity in the principal place of residence. This measure strikes the prior homestead exemption amounts, which were $75,000 for a single homeowner, $100,000 for married homeowners, or $175,000 for seniors and disabled homeowners. Under this measure, the homestead exemption is now the greater of $300,000 or the countywide median sale price of a single family home in the calendar year prior to the calendar year in which the judgment debtor claims the exemption, not to exceed $600,000. Again, these amounts remain as equity in the home, not total real estate value. Proponents of AB 1885 argued that the current homestead standards were antiquated and hadn't kept pace with inflation and median home prices in California. They also pointed to states outside of California with lower home costs but higher exemption amounts. While the new thresholds take effect on January 1st, any judgment already entered into prior to the effective date would still qualify for these expanded amounts if the plaintiff makes the decision to execute that judgment. In other words, nothing in the measure adheres existing judgments to the prior limitations of the homestead exemption. The new California law does not change any of the statutory exceptions to the homestead, such as state taxes. Those were not protected before this measure and will not be protected after. Procedurally, this was a budget bill that was introduced on the Friday afternoon prior to the final Monday deadline. So over the weekend, in the last 72 hours of the legislative session, this measure received brief hearings in both the Senate and Assembly budget committees and was approved by both houses. While perfectly legal, this late gut and amend budget bill bypassed the conventional vetting process of policy committee hearings and the 9-month conversation that we would typically see throughout the traditional legislative policy process. Here, typically budget bills are effective upon signature, but this measure does not meet certain criteria and will therefore become effective on January 1st, 2021. Moving on to the next slide, we will now touch on Senate Bill 908 by Senator Wieckowski. This is the Debt Collection Licensing Act, and it seeks to establish a licensing and examination framework for unlicensed debt collectors in California. Certain provisions, though, do go well beyond that scope. Specified institutions, including banks, are exempt from licensure under this act. Notwithstanding that exemption, the Act adds the Department of Business Oversight as an enforcer of the Rosenthal Fair Debt Collection Practices Act and the Fair Debt Buying Practices Act. This applies to both those entities licensed by the Act and those exempt from licensure. Currently, Rosenthal is enforced by the Office of Attorney General and an explicit private right of action. It provides for recovery of actual damages and statutory penalties. This measure is more broad and seeks to authorize the commissioner to order entities to pay ancillary relief in connection with violations. It also allows for refunds, restitution, disgorgement, and damages, and it allows the commissioner to, after notice and an opportunity for a hearing, issue desist and refrain orders. It is our understanding that the differences in remedies is intended to prevent situations where an entity could be subject to both a lawsuit by a debtor and to an administrative or civil action brought by the DBO for the same violation, although that scenario is not explicitly prevented in the measure's language. Moving on to the next slide, we will now transition to the topic of human resources and employment, and we will touch on two measures that present significant new compliance requirements for employers, beginning with Assembly Bill 685 by Assemblymember Reyes. This is a COVID response measure, and it requires employers to notify employees in instances of exposure to COVID-19. The measure creates a number of requirements and definitions, so we'll walk through a few key changes here. I'm going to editorialize for a moment and mention that supporters of the measure say that this is a crucial step in protecting many essential workers that are still on the job. However, opponents say that it's not exactly clear when employers have to sound the alarm to workers and what exactly needs to be disclosed. So I respectfully suggest that everyone take a look at this one under a microscope. That being said, the most important item to flag here is an addition to the labor code in section 6409.6. If an employer or representative of the employer receives notice of potential exposure to COVID-19, that employer must take a number of actions within 1 business day. Those actions are: 1, provide all employees and subcontracted employees who are on the premises at the same work site as the qualifying individual within the infection period with a written notice that they may have been exposed to COVID-19. This should be in the manner that the employer normally uses to communicate employment-related information. 2, provide all employees who may have been exposed with information regarding COVID-19 related benefits under applicable federal, state, and local laws. And 3, notify all employees on the disinfection and safety plan that the employer plans to implement and complete per the guidelines of the Federal Center for Disease Control. Of course, the measure also lays out a number of definitions for the aforementioned requirements, such as worksite and infectious period. In addition, if an employer is notified that its number of cases meet the definition of a COVID outbreak as defined by the State Department of Public Health, that employer has additional reporting obligations to their local public health agency, and that's within 48 hours. This must contain the same information that's already required in a Cal/OSHA Form 300 injury log. The measure also requires that employers must maintain records of those written notifications for a period of at least 3 years. And lastly, the employer is prohibited from retaliating against a worker for disclosing a positive COVID-19 test, diagnosis, or an order to quarantine or isolate. Workers who believe they have been retaliated against may file a complaint with the Division of Labor Standards Enforcement. There's a lot of nuances and technicalities associated with the drafting of this measure. So again, I respectfully recommend that folks begin taking a look at compliance associated with AB 685 soon, despite the measure's effective date of Jan 1. I'll also note that Cal/OSHA has provided some extensive COVID-19 related guidance for employers, and I will drop a link to that in the chat box. Employers should review those materials and ensure that they are updating their injury and illness prevention program, training employees about the risks associated with COVID-19 and documenting that training. Employers should also monitor and enforce all of their COVID-19 procedures. Next, we'll move on to Senate Bill 1383 by Senator Jackson. This is on the California Family Rights Act, or CFRA. It is not limited in scope to COVID. This is an expansion of leave provisions, and it was proposed back in January as part of the governor's draft budget. Either due to or in spite of the pandemic, depending on your lens, he made this proposal one of his 2020 priorities and signed it into law on September 17th. The measure goes into effect on Jan 1, and it significantly expands the state's existing family and medical leave entitlements. Current CFRA law provides qualifying employees with 12 weeks of protected leave during a 12-month period for their own medical condition or the medical condition of a spouse, child, or parent, or for the birth, adoption, or foster placement of a child. This measure expands the definition of qualified family members to include a grandparent, grandchild, sibling, domestic partner, or child of a domestic partner. This is an important change because those new family members are not covered by the Federal Family Medical Leave Act, or FMLA. CFRA and FMLA normally run concurrently, which is a 12-week or 3-month allotment. So for those large employers of 50 or more employees, this means that the employee could take 3 months to care for a newly defined member under CFRA, return to work, and then take another 3 months off under FMLA for their own medical condition or the medical condition of a spouse, etc. This opens the door to a potential of 6 months of job protected leave. I'll emphasize here that an employee can also take intermittent leave under both CFRA and FMLA in increments as small as 1 hour at a time. So California employers will have to properly track in order to protect themselves against potential liability. For small employers, those less than 50 employees, this measure expands protected leave to any employer with between 5 and 49 employees. Even though the leave is not paid, it is protected, meaning that an employer must return the employee to the same position they had before going out on leave. This measure does not permit an employer to refuse reinstatement of what are called key employees, as was previously allowed by CFRA under qualifying circumstances. However, eligibility requirements for an employee to qualify for this leave do remain the same. Another notable change is specific to employers who employ both parents of a child. Current law stipulates that the employer only has to grant both employees a combined total of 12 weeks of leave. This measure instead requires that both parents receive up to 12 weeks individually. Lastly, the leave mandated under SB 1383 is enforced through a private right of action that includes compensatory damages, injunctive relief, declaratory relief, punitive damages, and attorney's fees. Any employee who believes that an employer did not properly administer leave, interfered with leave, or denied leave can file litigation. So needless to say, there's a lot to dig into with this one. These provisions are significant changes to existing law that largely fall on the backs of employers and do present some new burdens from a compliance perspective. Again, if you have any questions about any of these issues discussed, please submit them through the chat box. That wraps up my portion of the legislative update, and I will now hand the mic off to Jason.
Thank you, Melanie. I'm Jason Lane, also with CBA in Government Relations. A grassroots groundswell has emerged over the past 3 years around the subject of public banking. Proponents of public banking believe that a government-run institution will do a better job at serving California's communities than private institutions. They believe that instead of paying commercial banks fees to manage their investments and deposits, state and local governments would be better off creating their own bank, which would be more aligned, they believe, with California's values. Unfortunately, the proponents of public banking don't appear to have a great deal of experience in banking, and we've spent considerable time educating policymakers on topics like capitalization, collateralization of deposits, the banking regulatory structure, and all of the operational costs that go into creating and maintaining a financial institution. One only needs to look at the Department of Motor Vehicles and the EDD as of late to question the wisdom behind letting the state run its own bank. Nevertheless, the proponents point to the Bank of North Dakota, which is the nation's only public bank, and that bank routes its public lending through community banks. And that bank has existed for more than 100 years and was formed because North Dakotans really had no alternative for banking services at the time. So this year we saw the introduction of AB 310 by Assemblymember Santiago, and this measure is the second legislative attempt to create a public bank in the same legislative session. Last year, the governor signed AB 857, which allows local governments to create their own public bank, and AB 310 is a variation on that concept, but creates a state bank by converting the existing iBank into a depository institution. The legislative intent is to create a public bank that will, and I'll read straight from the bill, aid economic recovery for individuals and local governments who are facing extreme economic pressure due to COVID-19 pandemic and subsequent economic recession by increasing lending to local agencies and creating credit to rural, minority-owned, women-owned, indigenous-owned, and immigrant-owned businesses who have been historically marginalized due to restrictive covenants, redlining, and other restrictive practices by traditional financial institutions via credit enhancements and participation lending with local financial institutions. This measure requires that the state treasurer deposit 100% of the deposits in the state treasury into the public bank. And finally, the measure sets forth a lending program that the new bank would have to execute, which includes everything from, well, there are some fairly lax underwriting criteria involved and could include high-risk products like payday loans and title loans. And the measure failed to advance this year. It did receive a policy committee, and during that policy committee hearing, there was a willingness expressed by the chair of that particular committee to hold interim hearings over the fall prior to the legislature coming back in January. These would be mostly informational hearings, but the proponents of creating a public bank have vowed to come back with a new bill next year. On the topic of taxation, many voters will have the opportunity to, all voters in California, to vote on Proposition 15, which is a split roll initiative. And this is a ballot initiative that would overturn the landmark ballot measure Prop 13, which was passed by the voters in 1971 by reassessing commercial property at present day value. It would raise an estimated $11 billion a year for schools and local governments. It proposes reassessment to fair market value for commercial and industrial real property, with continued reassessment to fair market value at least once every 3 years. Reassessments will commence on lien dates for the 2020-23 fiscal year. There are several exemptions to the measure. It exempts, for example, businesses with 50 or fewer employees, and it exempts the first $500,000 of tangible personal property per taxpayer. It also exempts zoned real property owned by taxpayers that operate a business where the real property of the total aggregate owned property of the business is less than $2 million statewide. And then for mixed use property, only the portion of the property that is used for commercial and industrial purposes would be subject to reassessment. The ballot measure is opposed by leading business organizations, including California Bankers Association and the California Chamber of Commerce. From a reg compliance perspective, one of the interesting issues that we have heard about is that this measure could potentially threaten the commercial lending underwriting practices of our member institutions, particularly given the fact that many of these properties will face a sizable assessment and could in fact impair cash flow for a borrower. You might not typically think that a banking association would find itself in a product liability fight, but we found ourselves engaged late in the legislative session this year when AB 3262 was significantly amended late with about 2 weeks prior to adjournment. California courts have long held that retailers can be held liable for product defects if they played an integral role in bringing the product to the marketplace. AB 3262 extends the same strict liability to electronic retail marketplaces and added, by way of those late amendments, that the mere facilitation of bringing a defective product into the stream of commerce could trigger liability. The distinction between existing case law and AB 3262 is an important distinction. In that ever since the Bay Summit case was settled in 1996, the courts have held that retailers could be held strictly liable if 3 factors are present. The first is that the defendant received a direct financial benefit from its activities and from the sale of the product. The second is that the retailer or defendant, that their role was integral to the business enterprise such that the defendant's conduct was necessary factor in bringing the product to the initial consumer marketplace. And the third and final test is that the defendant had control over or substantial ability to influence the manufacturing or distribution process. Unfortunately, AB 3262 did not have any test. Under the measure, if you're an electronic retail marketplace, you're a retailer. If you're a retailer, you're liable. Which brings us to the reason for our chief concern with the measure. We were concerned that a plaintiff's attorney could argue that a credit card issuer maintaining a platform whereby a cardholder could utilize points to purchase a product through the issuer's website is jointly liable for product defects. The argument could further be enhanced if the card issuer derives a financial benefit from the relationship with the retailer. The measure ultimately was held by the author, but they have expressed a strong desire to move forward with the measure next year. We have spent considerable time on local government issues this year, principally in the city and county of Los Angeles. There is an advocacy organization called Healthy LA that has been working with the county to address mortgage forbearance. And the county here is particularly focused on mortgage forbearance tied to rent forgiveness and tracking banks who are or who are not providing landlords with mortgage forbearance. The county is considering mandating that all banks operating within the jurisdiction of the county to provide data on mortgage forbearance specifically tied to rent relief. And they are considering creating a scorecard rating the banks that are providing this data. It is been an effort, but I think we're gaining some traction in convincing the Los Angeles County that banks typically don't track forbearance related to rent forgiveness, and that a financial institution may have no idea how a property is being used or if it is being used for rental purposes. In fact, the CARES Act, the Federal CARES Act specifically prohibits a bank from acquiring additional information when they are providing forbearance on a mortgage loan. With that, I will hand the presentation over to Kevin.
Thank you, Jason. And my name is Kevin Gould, and I'm Senior Vice President and Director of Government Relations for the California Bankers Association. Thank you so much for joining us today. We appreciate the opportunity to provide a legislative update, and we want to thank you for all the amazing work that you do supporting your customers and your communities. We're going to talk a little bit now about mortgage relief that we saw emerge this legislative session. And given the COVID-19 pandemic, we saw a number of measures that moved forward and that were introduced seeking to provide various forms of mortgage relief. Some of those measures were specific to residential 1 to 4 properties. Some of them also applied to multifamily 5+. The measure that we're going to talk about is Assembly Bill 3088 by Assemblymember Chu. And this measure was ultimately signed by the governor just before midnight on August 31. The measure is the product of negotiations with the governor's office and with stakeholders, and one that ultimately the association supported. So let's talk about the details. This measure is titled the Small Landlord and Homeowner Relief Act, and there are various components to this particular measure. First, the measure expands the California Homeowner Bill of Rights to cover non-owner occupied residential 1 to 4 properties. Now, mortgage servicers are very familiar with the California Homeowner Bill of Rights. The Homeowner Bill of Rights was enacted in 2012 following the Great Recession. And the Homeowner Bill of Rights essentially requires that a mortgage servicer outreach to and consider borrowers for foreclosure prevention alternatives. Prior to Assembly Bill 3088, the law required that these provisions apply to owner-occupied residential 1 to 4 properties. With Assembly Bill 3088, the same requirements that exist today under the Homeowner Bill of Rights will now apply to non-owner occupied residential 1 to 4 properties. In addition to these provisions, Assembly Bill 3088 also requires, in the context of residential 1 to 4, that servicers provide written notice when they deny a forbearance request made by a borrower between August 31, 2020 and April 1, 2021. Again, this written notice requirement is in those circumstances where you deny a forbearance request during that effective time period. This written notice must set forth the reason or reasons why forbearance was not provided. And if there is a defect in the borrower's request, if there is information or something that would have otherwise been persuasive for the servicer considering that forbearance request, then the borrower is granted an opportunity to revise the request, and they can send in a new request, but it must be received within 21 days from the mailing of the notice. All right, in addition to these provisions, we'll move to the next slide, please. Servicers must respond to that revised request within 5 business days. Now, this written notice requirement applies to circumstances where borrowers were current as of February 1, 2020, so that it does not apply to those delinquencies prior to February 1, 2020. Again, really trying to address the circumstances surrounding the pandemic. In addition, the written notice requirement applies where there is a borrower who experiences a financial hardship due directly or indirectly to COVID-19. And those requirements are very similar to what we have seen in the Federal CARES Act. Speaking about the Federal CARES Act, This requirement to provide written notice, there are exemptions to it, and these are important to highlight. For servicers that comply with the CARES Act for federally backed mortgages, those servicers are deemed to be in compliance with the section. And for those servicers who provide consistent treatment with the CARES Act for non-federally backed mortgages. So if you treat those non-federally backed mortgages consistently with what's required under the CARES Act, then you will too be exempt from the provisions of this particular section. All right, and we'll move to the next slide to talk about some additional provisions that are part of Assembly Bill 3088. Again, the governor signed this, so these are important to pay attention to. Assembly Bill 3088 also deals with post-forbearance. So after a borrower concludes their forbearance period, the repayment provisions in order to bring that borrower current. Assembly Bill 3088 requires that mortgage servicers follow applicable federal guidance with respect to post-forbearance options. Here again, for a mortgage servicer that follows relevant guidance for federally backed mortgages, you will be exempt from these requirements in Assembly Bill 3088. And if you are a mortgage servicer who reviews customers consistent with federal guidance for non-federally backed mortgages, then you too will have an exemption from this section of law. Now, Assembly Bill 3088 comes with significant penalties for violations. And these violation penalties are familiar to us since they are derived from California's Homeowner Bill of Rights. For failures to comply, a plaintiff can bring a private right of action where they may recover attorney's fees and court costs as early as a preliminary injunction. And so those are important penalties to pay attention to. Importantly, Assembly Bill 3088 does not impose a foreclosure moratorium, nor does it require mandatory forbearance. In several of the measures that we saw advance during the legislative session that ultimately failed passage, several of those measures attempted to impose a 12-month foreclosure moratorium and also sought to impose up to 12 months of mandatory forbearance. Again, Assembly Bill 3088 does not impose a moratorium, nor does it mandate forbearance. Okay. Now we're going to talk a little bit about the Department of Financial Protection and Innovation. This is a proposal that was part of the governor's January budget. And this particular proposal came forward because of a concern about a shift in federal priorities with regard to the Federal Consumer Financial Protection Bureau. Assembly Bill 1864 Lamone restructures the Department of Business Oversight, the state entity that currently oversees state chartered banks and credit unions, and it establishes instead the Department of Financial Protection and Innovation. Among other provisions, the measure requires registration of unlicensed entities who offer financial products or services. And with regard to this provision, with regard to registering unlicensed individuals who are offering financial products or services, CBA was appreciative and supportive. We also were appreciative and supportive of the idea that the department would focus more on innovation. AB 1864 also enhances enforcement authority for the Department of Financial Protection and Innovation in allowing the department to enforce unfair, deceptive, abusive acts or practices. Ultimately, this measure came together at the end of session and passed and was sent to the governor for consideration. Let's move to the next slide and talk a little bit more about the details in Assembly Bill 1864. The measure underscores the fact that the commissioner can bring a civil action or pursue other appropriate proceedings to secure remedies under Dodd-Frank Section 1042. And Dodd-Frank Section 1042 presently authorizes the state to take action against state licensees, and allows the Attorney General to bring actions as well against federally chartered institutions. Remedies that may be obtained through Dodd-Frank include disgorgement, restitution, and rescission of contract. Now, these amendments, with respect to underscoring the fact that the commissioner can bring an action or pursue an appropriate proceeding, are included in Financial Code 326, which was a current section under the general provisions of the Financial Code. Now, when this authority was underscored in Section 326 of the Financial Code, we also requested and secured an amendment underscoring the fact that nothing is to be construed to expand upon or limit the authority granted by Dodd-Frank under Section 1042. So you'll see those amendments in Section 326. In addition, Assembly Bill 1864 establishes Division 24, which is in the 90,000 series of the Financial Code. And this is where you'll find the provisions that establish the registration requirement for entities that are unlicensed offering financial products or services. Now, we were successful at negotiating amendments which exempt federally chartered banks and state chartered banks from this new division, which is called the California Consumer Financial Protection Law. Now, state chartered banks are exempt whether they are chartered in the state of California or chartered in any other state. So we were pleased to secure those amendments and pleased to see this measure move forward. Okay, we're going to move on and we're going to talk about the California Privacy Rights Act of 2020. And this will appear as Proposition 24 on the November 2020 general election ballot. And this particular proposition expands upon a law that we are very familiar with as financial institutions, known as the California Consumer Privacy Act. CCPA was adopted by legislation in 2018. This particular proposition, Proposition 24, is brought forward by the same proponent that brought forward CCPA of 2018. So what does the proposition do? Among other provisions, Proposition 24 expands the California Consumer Privacy Act by adding a new right to correct inaccurate personal information. This new right will join the other pillars, the other rights that are currently part of CCPA. CCPA includes the right to know the kind of information that a business collects about the individual, the right to delete personal information that the business collects, the right to prohibit the sale of personal information, the right to not be discriminated against for a consumer's exercising of their rights under the CCPA, and a right to sue. Under existing law, under the CCPA, a consumer can sue for violations of the CCPA when there is a data breach. The other underlying provisions of the CCPA are presently enforceable by the Attorney General. Proposition 24 also establishes a privacy protection agency, and should voters approve this proposition, the authority, whether it's enforcement or rulemaking, that presently reside with the Department of Justice, the California Attorney General, will transfer from DOJ to this new privacy protection agency. So on a go-forward basis, enforcement and rulemaking will be done under the Privacy Protection Agency. Now, the California Privacy Rights Act of 2020 remains intact. It keeps intact the Gramm-Leach-Bliley exemption. So for information collected, processed, sold, or disclosed pursuant to GLBA, that exemption continues to exist without amendment. The California Privacy Rights Act of 2020 importantly also extends two exemptions for employee personal information and business-to-business commercial transaction personal information. And it extends those exemptions until January 1 of 2023. This is important because those exemptions would otherwise expire on January 1 of 2021. All right, we're going to talk about Assembly Bill 1281 by Assemblymember Chow. And this is still on the topic of privacy. This relates to the California Consumer Privacy Act, which we just talked about. This particular measure continues the exemptions for employee and business-to-business personal information until January 1 of 2022. Now, this particular measure is only operative if voters do not approve the California Privacy Rights Act of 2020 that we talked about one slide ago. So this is a measure that attempts to cover the circumstance in the event that voters do not approve the California Privacy Rights Act of 2020. In either case, whether Assembly Bill 1281 continues the provisions, the exemptions for employee and B2B PI until January 1 of 22, or whether the California Privacy Rights Act of 2020 passes and extends those exemptions until January 1 of 2023, advocacy efforts are going to be ongoing to extend those two exemptions beyond those time periods. So more to follow with respect to those exemptions. With that, this concludes our presentation. We thank you so much for your willingness to join us today and share some time to talk about a California legislative update. Again, thank you for the amazing work that you do to support your customers and communities. If you have any questions with regard to state advocacy efforts, please do not hesitate to contact us. We've included our email address and phone numbers on this slide, and please let us know what more we can do to support you. We hope you enjoy the balance of the conference and look forward to the opportunity to speak with you again. Take care, everyone.